वेल हेलो गाइस। आज कंटिन्यू करते जो लास्ट वीक छोड़ के चले गए थे तब तक उसके। एक बार वॉइस चेक कर लेता हूँ मैं। इस बार 1.5-2 घंटे की रीडिंग करनी है। एक ही घंटे तक रीड कर पाता हूँ, उसके बाद मेरा मुंह दुखने चालू हो जाता है। चलो चलो। तो देखते हैं भाई, पहले ही मेरा सर दुख रहा है अब। अब नहीं पता भाई कितना देर तक करूँगा, लेकिन 1 घंटा तो कैसे भी करूँगा। और ये यहाँ पर इंग्लिश भी थोड़ी डिफिकल्ट है। लॉजिकल लॉ वाली इंग्लिश है, इसलिए थोड़ा लॉ वाली इंग्लिश है। चलो। डेफिनेशन ऑफ मनी मिल शायद यहाँ तक करा था, इसको भी कंप्लीट किया था। अब हम 200 आर्टिकल 200 पे चालू करेंगे। सेंट ऑफ बिल्स। When a bill has passed by the legislative assembly of state, or in the case of state having a legislative council, has been passed by both of the houses of the legislature of the state, it shall be presented to the governor, and the governor shall declare either that he assent to the bill or that he withholds assent therefrom, or that he reserve the bill for the consideration for of the president. Okay, maybe I will check what the fuck assent means. To agree to a proposal, agreement. Fucking bitch. Agreement, act of agreeing. I will give this act. ओके एग्रीमेंट, ओके एग्रीमेंट। किसी चीज से एग्री करना उसको कहा जाता है। देयर फ्रॉम और दैट ही रिजर्व द बिल फॉर द कंसिडरेशन ऑफ द प्रेसिडेंट, प्रोवाइडेड दैट द गवर्नर में एज सून एज पॉसिबल as soon as possible after the presentation of him of the bill for assent, return the bill if it is not a money bill together with a message requesting that the house or houses will reconsider the bill of or any specified provision thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message, and when a bill is so returned, the house or houses shall reconsider the bill accordingly, and if the bill is passed again by the house or houses with or without amendment and presented to the governor for assent, the governor shall not withhold assent therefrom. Provided further that the governor shall not assent to, but shall reserve for the consideration of the president any bill which, in the opinion of the governor, would, if it became law, to so derogate from the powers of High Court as to endanger the position which that court is by this constitution designed to fill. ओके, शायद शायद ऐसा बिल जो हाई कोर्ट की पावर को काफी कम कर देता है, वो ऐसे बिल को गवर्नर एग्री नहीं करने वाला और उसको प्रेसिडेंट को दिखाएगा, कुछ इस तरह से कुछ है ये। डिजाइन टू फिल आर्टिकल 201 bills reserved for consideration. When a bill is reserved by a governor for the consideration of the president shall declare oh, either that he assent to the bill or that he withholds assent therefrom, provided that where the bill is not a money bill, the president may direct the governor to return the bill to the house, or as the case may be, the house of the legislature of the state, together with such a message as is mentioned in the first proviso to Article 200. And when a bill is so written, the house or houses shall reconsider it accordingly within a period of 6 months from the date of receipt of such message, and if it is again passed by the house or houses with or without amendment, it shall be presented again to the president for his consideration. ओके, अगर गवर्नर ने कोई बिल पास हुआ है उसको प्रेसिडेंट के कंसिडरेशन के लिए रखा है, तो प्रेसिडेंट कह सकता है कि इस बिल को वापस भेजो और ये मैंने चीज़ें रिकमेंड की है, अमेंडमेंट डालो इस बिल में, और फिर उसको पास कर दो, तो गवर्नर उसकी बात एक्सेप्ट कर सकता है। आई थिंक गवर्नर डायरेक्टली आंसर्स टू द प्रेसिडेंट। दिस इज द केस विथ आर्टिकल 201। ओके, आर्टिकल 202 एनुअल फाइनेंशियल स्टेटमेंट। The governor shall, in respect of every financial year, cause to be laid before the house or houses of the legislature of the state a statement of the estimated receipt and expenditure of the state for that year. In this part, referred to as the annual financial statement. Clause 2. The estimates of expenditure embodied in the annual financial statement shall show separately. Subclause A. The sums required to meet expenditure described by this constitution as expenditure charged upon the consolidated fund of the state, and uh, subclause B. The sums required to meet other expenditure proposed to be made from the consolidated fund of the state, and shall distinguish expenditure on revenue account from other expenditure. Okay. Clause 3. The following expenditure shall be expenditure charged on the consolidated fund of each state. The emoluments and allowance of the governor and other expenditure relating to his office. एम्यूलमेंट्स यानी कि सर्विसेज, ये सब इसको एम्यूलमेंट्स कहते हैं भाई, मुझे जैसे पता है। The salary and the allowances of the Speaker and the Deputy Speaker of the Legislative Assembly, and in the case of state having a Legislative Council, also of Chairman and the Deputy Chairman of the Legislative Council. Okay. C. Subclause C. Debt charges for which the state is liable, including interest, sinking fund charges, and redemption charges, and the other expenditure relating to the raising of loans and the service of and redemption of debt. हाँ बस खर्चा पानी या मतलब ये इकोनॉमी का है, स्टेट की इकोनॉमी का उसकी बात हो रही है। जो स्टेट पे कर्जा होता है उसको जो भरने में जो उसका इंटरेस्ट होता है उसको भी एक्सपेंडिचर में डाला जाएगा, जो कि बिल्कुल भी सही बात है, वैसा ही होना चाहिए। Expenditure in respect of the salaries and allowances of judges and of any high court. Any subclause, any sums required to satisfy any judgment, decree, or award of any court or arbitral tribunal. Okay. Yep. Any other expenditure declared by this constitution or by the legislature of the state by law to be charged. Okay. Article 203. Procedure in legislature with respect to estimates. So much of the estimates as relates to expenditure charged upon the consolidated fund of a state shall not be submitted to the vote of the legislative assembly. But nothing in this clause shall be construed as preventing the discussion in legislature of those estimates. Okay. वोट नहीं कर सकते लेकिन डिस्कस कर सकते हैं इसके बारे में कि किस पे खर्चा कर रहे हो, समथिंग लाइक दैट. Okay. Clause 2. So much of the said assessment as relates to the other expenditure shall be submitted in the form of demands for grant to the Legislative Assembly, and the Legislative Assembly shall have power to assent or to refuse to assent to any demand or to assent to any demand subject to a reduction of the amount specified therein. Clause 3. No demand for grant shall be made except on the recommendation of the governor. ग्रांट्स यानी कि पैसे देख, ठीक है, थोड़ा क्लियर मीनिंग जान लेते ग्रांट्स का. टू गिव विश टू एग्री समथिंग. या यानी कि किसी प्रोजेक्ट को ग्रांट वेंट दे दिया, उसके लिए तुम पैसे की मंजूरी कर दिए, तो उसको ग्रांट कहा जाता है भाई. अप्रोप्रिएशन बिल्स आर्टिकल 204. As soon as may be after the grants under Article 203 have been made by the Assembly, there shall be introduced a bill to provide for the appropriation out of the consolidated fund of the state of all monies required to meet. Subclause A, the grant so made by the Assembly, and subclause B, the expenditure charge on the consolidated fund of the state, but not exceeding any case the amount shown in the statement previously laid before the House or Houses. Clause 2. No amendment shall be proposed to any such bill in the House or either House of the Legislature of State, which will have the effect of varying the amount of altering the destination of any grant so made, or of varying the amount of any expenditure charged on the consolidated fund of the state, and the decision of the person presiding as to whether an amendment is inadmissible under this clause shall be final. ओके, मतलब तुम एक बार किसी चीज को ग्रांट दे दिया तो तुम उसका उसकी कहाँ पर देना है, उस ग्रांट को खर्चा कहाँ करना है, वो बदल नहीं सकते। आई थिंक वो कह रहा है। कभी कभी मैं ऐसे बोलते बोलते पढ़ नहीं पाता भाई, मुझे फिर जोन आउट होके अपने आप में पढ़ लेना पड़ता है, और फिर से एक बार पढ़ने के बाद समझ में आ जाता है। Subject to the provisions of Articles 205 and 206, no money shall be withdrawn from consolidated fund of the state except under appropriation made by law passed in accordance with the provision of this article. Okay, that is valid, I guess. Okay, this law seems valid and a good law. Uh, 205. Article 205, supplementary, additional, or excess grants. The governor shall, uh, subclause A, if the amount authorized by any law made in accordance with the provisions of Article 204 to be expended for a particular service for the current financial year is found to be insufficient for the purposes of that year, or when a need has arisen during the current financial year for supplementary or additional expenditure upon some new service not contemplated in the annual financial statement for that year, or B, if any money has been spent on any service during a financial year in excess of the amount granted for that service and for that year, cause to be laid before the House or the Houses of the Legislature of the state. Another statement showing that the estimated amount of that expenditure or cost to be present to the Legislative Assembly of State a demand for such excess, and the case may be. हाँ, ये तो लगभग हर एक प्रोजेक्ट में हो ही जाता है, सरकार का हर एक प्रोजेक्ट जितना कैलकुलेट करा था कि इतना खर्चा होगा, उससे ज़्यादा ही खर्चा हो जाता है, तो शायद वो गवर्नर को दिखा के फिर समझा लेते हैं। Clause 2. The provisions of Article 202, 203 and 204 shall have effect in relation to any such statement and expenditure or demand, and also to any law to be made authorizing the appropriation of monies out of the consolidated monies. Okay, I don't think there is a plural for money. Monies is, I think, a wrong word. Well, let me fucking check it. Or maybe a spelling mistake. Yeah, it is a plural for money with obtained with humorous intention. Plural of money used in a sense of plural multiple currency. Okay, maybe the guy used it in humorous way, but I don't see any humor in this. Maybe the entire fucking, yeah, this article may be humorous because obviously supplementary, additional, or excess grants. Yeah, every fucking project cost excess and needs supplementary budget. Clause 2. The provisions of Article 202, 203, and 204 shall have in relation to any such statement and expenditure or demand, and also to any law to be made authorizing the appropriation of monies out of the consolidated fund of the state to meet such expenditure or the grant in respect of such demands as they have effect in relation to the annual financial statement and the expenditure mentioned therein, or to demand for a grant and the law to be made for authorization of appropriation of monies out of the consolidated fund of the state to meet such expenditure or grant. Okay. 206, Article 206, votes on account, votes of credit, and exception grants. Notwithstanding anything in the foregoing provisions of this chapter, the Legislative Assembly of the state shall have power, subclause A, to make any grant in advance in respect of the estimated expenditure for a part of any financial year, pending the completion of the procedure prescribed in Article 203 for the voting of such grant and the passing of the law in accordance with provisions of Article 204 in relation to that expenditure. Clause B. To make a grant for meeting an unexpected demand upon the resources of the state when no, on account of the magnitude or the indefinite character of the service, the demand cannot be stated with the details ordinarily given in annual financial statement. C. To make an exceptional grant which forms no part of the current service of any financial year. And the legislature of state shall have power to authorize by law the withdrawal of monies from the consolidated fund of the state for the purposes of which the said grants are made. Okay. 2. The provisions of Article 203 and 204 shall have effect in relation to the making of any grant under Clause 1 and to any law to be made under that clause as they have effect in relation to the making of a grant with regard to any expenditure mentioned in the annual financial statement and the law to be made for the authorization of appropriation of monies out of consolidated fund of the state to meet such expenditure. Article 207 special provision as to financial bill. A bill or amendment making provision for any of that matter specified in subclause A to F of clause 1 of Article 199 shall not be introduced or moved except on the recommendation of governor, and a bill making such provision shall not be introduced in legislative council, provided that no recommendation shall be required under this clause for the moving of an amendment making provision for the reduction or abolition of any tax. Article subclause 2. A bill or amendment shall not be deemed to make provision for of that matters approved said by reason only that it provides for the imposition of fines or other pecuniary penalties or for the demand or payment of fees for licenses or fees for services rendered or by reason that it provides for the imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. 3. A bill which, if enacted and brought into operation, would involve expenditure from the consolidated fund of a state shall not be passed by House of the Legislature of the state unless the governor has recommended to the House that the House consideration of the bill. Yeah, I mean the governor has lots of power, I guess, and many important decisions. Other than that, I don't know. Ooh. Article 208 Rules of Procedure. A House. Okay, I am one third done with this book or constitution. Yeah, Article 208, Rules of Procedure. A House of the Legislature of a state may make rules for regulating subject. The provision of this constitution, its procedure and conduct of its business. Clause 2. Until rules are made under Clause 1, the rules of procedure and standing orders in force immediately before the commencement of this constitution with respect to the legislature for the corresponding province shall have effect in relation. Okay. I mean, here the word province is used, not the word state, because there is only one state. Provinces can be multiple. Even states can be multiple. Okay, I don't know. It's not even inside one country. Province sound cooler. Yeah, I mean Chinese provinces. It definitely sounds cooler in some regard. In relation to the legislature of the state, subject to such modification and adaptation as may be made therein by the Speaker of the Legislative Assembly or the Chairman of the Legislative Council as the case may. या अब तक तो लॉ बन जाएंगे ना लॉज वन के हिसाब से like 70-80 years have been passed since the constitution was written, so I think most likely the new rules are sorry, procedures are made, not laws. 3. In a state having a legislative council, the governor, after consultation with the Speaker of the Legislative Assembly and the Chairman of the Legislative Council, may make rules as to the procedure with the respect to communication between the two houses. Yeah, okay. I mean, only I think 4 Indian states have uh what is called Legislative Council. 4 or 6. I think only 4 have. Maharashtra, UP, maybe Tamil Nadu, and Bihar, I guess. Wait, we will see. Yeah, only 6 have. Not Tamil Nadu, it is Andhra Pradesh, Bihar, Karnataka, Maharashtra, Telangana, Uttar Pradesh. 6. 3 state from the south and 2 state from the north and 1 state from the middle. Okay. In a state having a legislative council. Okay, I already read that. 209, Article 209, regulation by law of the procedure in the legislature of the state in relation to financial business. The legislature of a state may, for the purpose of the timely completion of financial business, regulate by law the procedure of and the conduct of business in the house or houses of legislature of the state in relation to any financial matter or to any bill for the appropriation of monies out of the consolidated fund of the state, and so far as any provision of any law so made is inconsistent with any rule made by the house or either house of the legislature of the state under clause 1 of article 208, or with any rule or standing order having effect in relation to the legislature of the state under clause 2 of the article, such proviso shall prevail. Yeah, what? Okay, even it is if it is inconsistent, it can prevail. I'm reading it correctly or I am missing something. Okay, man, I don't know. I read it and I think, yeah, the provision will be prevailed, which was made earlier. Okay, 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 it is right. 200, 210. Language and Article 210. Language to be used in the legislature. Okay. Clause 1, notwithstanding anything in part. Okay. 15, I guess. No, 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 no. Part 17. I don't know, man. Let's fucking see. Yeah, 17. Yeah. Part 17. Notwithstanding anything in Part 17, but subject to the provisions of Article 348, business in the legislature of state shall be transacted in the official language or languages of the state or in Hindi or in English, provided that the Speaker of the Legislative Assembly or Chairman of the Legislative Council or person acting as such, as the case may be, may permit any member who cannot adequately express himself in any of the languages appropriate to address in the House in his mother tongue. Okay, I mean, it is quite obvious, if he can't just speak in any language previously mentioned, then you can really can, he can, you can only, he can speak in his own only mother tongue now. Wow. Why it is written as a, you know, subclause of this article? If he can't speak any languages other than his own mother tongue, then yeah, he should be allowed to do that. Isn't it quite obvious? Clause 2. Unless the legislature of the state by law otherwise provides. From now on, I will say clause 2 210. I will not mention article. And I will only mention article when I'm starting. Okay, so I am making this change. Let's see how that pans out. Yeah, I am going down, you know. Unless clause 2 210, unless the legislature of the state by law otherwise provide, this article shall, after the expiration of a period of 15 years from the commencement of this constitution, have effect as if the words or in English were omitted therefrom. Okay, man. I mean, they are hoping that we Indians gonna stop using English, but oh God, it has been Pretty much the opposite. Provided that in relation to the legislature of the state, Himachal Pradesh, Manipur, Meghalaya, and Tripura, this clause shall have effect as if for the words 15 years occurring therein, the words 25 years were substituted. Provided further that in relation to the legislation of the states of Arunachal Pradesh, Goa, and Mizoram, this clause shall have effect as if for the words 15 years occurring therein, the words 40 years were substituted. Okay, what the fuck is this useless? 14 years were substituted, 15 years were substituted. This time I brought water because my neck, not neck, not throat gets quite dry, man. So I had to bring water. 200 and Article 211. Article 211. Which is sexy? 211 or Article 211? Article 211 is sexy. Restriction or discussion in the legislature. No discussion shall take place in the legislature of state with respect to the conduct of any judge of the Supreme Court or of High Court in the discharge of his duties. Okay, I mean, why this is special case for the judges? Like 70 years have been passed since maybe this was written. I think the discussion should be had, man. This special status given to the Supreme Court and High Court judges should be removed. Some of their judgments are terrible. Recently the current CGI said we are cockroaches, unemployed youth and RTI activists are cockroaches. Why the fuck people shouldn't be talked about that? In the discharge of its duties. Okay, maybe discharge of his when he is discharging his activities. Yeah, the language used here is very funny, man. Yeah, it is very complex. It can be written in easier words, okay? I think there should be a constitution of India in easier words. Like I read hard books and it is getting difficult for me. 212. Article 212 course not to inquire into proceeding of the legislature. Okay, why this has been done? Okay, many people will say, oh, it is due to protect the democracy and neither party overrides each other. I mean, like, okay, it was maybe created because of that, but the thing is that both parties have submerged and both parties are not in much of a disagreement with each other anyway. The courts and the MLAs don't have much disagreements. The House of Legislature Legislature Assembly doesn't have much of a disagreement. The courts, the judges, and the politician hang out together now. They are the same people, in fact. The validity of any proceedings in legislature of a state shall not be called in question on the ground of any alleged irregularity of the procedure. Okay, why the fuck it shouldn't be called? Clause 2, 212. No officer or a member of the legislature of the state in whom powers are vested by or under this constitution for regulating procedure or the conduct of business or for maintaining order in the legislature shall be subject to the jurisdiction of any court in respect of the exercise by him of those powers. Why? Okay, maybe the second might be understandable, but why the fuck the courts make a comment on irregularity of procedure? Okay, this is very stupid, man. Like, and the first one is even stupider. The Supreme Court judges are not elected by people, but the politicians, MLA, MPs are elected by the people, but they cannot discuss about the Supreme Court judges and High Court judges. Why? I mean, there many of the recent judgments are terrible. Have been terrible. Like they have been pretty much terrible, and I want my MLA to talk about it. I That's why I fucking voted. You know, so she can talk what I want to talk. But here they just can't talk about it. What the fuck is this? Article 213. Power of governor to promulgate ordinance during recess of legislature. ओके promulgate क्या होता है? To make known or make public. ओके 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 मतलब चालू होने से पहले एक बार बता देना ये लॉ है इसको इसको कुछ लाइक समथिंग लाइक दैट. Clause 1. If at any time, except when the legislative assembly of a state is in session or where there is a legislative council in a state, except when both houses of the legislature are in session, the governor is satisfied that circumstances exist which render it necessary for him to take immediate action. He may promulgate such ordinance as the circumstances appear to him to require, provided that the governor shall not withhold instruction from the president promulgate any such ordinance if subclause a bill containing the same provisions would under this constitution have required the previous sanction of the president for the introduction thereof into the legislature, or B. He would have deemed it necessary to reserve bill containing the same provision for the consideration of the president. Okay, I am not understanding what the fuck they are talking here. C. An act of legislature of the state containing the same provisions under this constitution have been invalid unless having been reserved for the consideration of the president, it had received the assent of the president. मतलब कुछ important bills he cannot promulgate अगर प्रेसिडेंट के पास वो बिल रहा होगा और उस पे अभी वो सोच रहे होंगे। Clause 2, 213. An ordinance promulgated under this article shall have the same force and effect as an act of the legislature of the state assented to by the governor. But every such ordinance, uh, subclause A, shall be laid before the legislative assembly of the state, or where there is a legislative council in the state, before both the houses, and shall cease to operate at the expiration of 6 weeks from the reassembly of the legislature, or before the expiration of that period. A resolution disapproving it has passed by the legislative assembly agreed to by the legislative council, if any, upon the passing of the legislation, or as the case may be, on the resolution being agreed to by the council, and B, may be withdrawn at any time by the governor. Explanation: where the houses of the legislature of state having a legislative council. A summon to reassemble on different date, the period of 6 weeks shall be reckoned from the later of those days for the purpose of this clause. Provided that for the purposes of the provision of this constitution relating to the effect of an act of the legislature of state which is repugnant. What the fuck ordinance means actually? I have to know that. Ordinance means, I guess, a type of a law which is, recommended by the president and the governor. Okay, okay, now I understand this much. Okay, now I understand it. I have to fucking remove the reflecting glasses, man. Power. Oh my god, how much lights matters. Light matters, man. Like, I switched to dark mode. Suddenly everything turned black. Shall be late before the. Okay, I understand this. Okay, it is little bit difficult for me to understand. I'm gonna move forward. Article 214. High courts for state. There shall be high court for each state. Okay. What does this mean? I don't know, man. Like 2 and 3. Article 215. High courts to the courts of record. Every high court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Wait, what the fuck? Article 216. Constitution of High Courts. Every High Court shall consist of a Chief Justice and such other judges as the President may from time to time deem it necessary to appoint. 3. Okay, what does this star represent, man? I don't know. Article 217. Appointment and condition of the office of a judge of a high court. He should be Indian. He should be not have any government position of power. No, no, position of profit, something like that. Every judge of a high court shall be appointed by the president by warrant under his hand and seal on the recommendation of National Judicial Appointments Commission referred to in Article 124A and the governor of the state, and in the case of appointment of judge other than the chief justice, the chief justice of high court shall hold office in the case of an additional or acting judge as provided in article. In and in any other case until he attains the age of 62 years, provided that Clause 1. A judge. Clause 1. No. Subclause A. A judge may, by writing under his hand, addressed to the president, resign his office. Subclause B. A judge may be removed from his office by the president. Okay, what the a high court can judge less. So basically, a judges can a judge may be removed from his office by the president in the manner provided in clause 4 of Article 124 for the removal of a judge of the Supreme Court. Okay, I don't know. I don't remember that. Should we go back there? Okay, we gonna go back to Article 124. Now we are at page number 100. 124. Here it is. अरे कितने लॉ है? ओके, क्लॉज 4 में दिया है. चलो क्लॉज 4 देख. ओके. A judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of Parliament, supported by a majority of the total membership of that House, and by a majority of not less than two-thirds. Okay. It is not easy. Yeah, that's why we don't see judges being removed. It is not. It is. I mean, the BJP won the current. In fact, BJP never had such kind of majority, two-third majority. Since 2014, BJP never had two-third majority. In fact, in its entire existence, BJP never had two-third majority. Once your party fucking crosses two-third majority, like you become literally bop. You can do pretty much whatever the fuck you want. You can change the many things in constitution. You can fucking fire judges. Yeah, but two-third majority is a lot. Like I think it has only happened when Indira Gandhi was assassinated and after independence Nehru got such kind of majorities. So I think I don't know, man, what to say about this. I mean, okay, two-third majority, you can now fire even a Supreme Court judge. I mean, like Supreme Court judges are shits or motherfuckers. Like yeah, you fucking call us cockroaches. Now take it. I don't fucking care about you. Let them fucking fire you. You are not worth the fucking trouble. I would have not said such words if they, if the guy, current Supreme Court CJI didn't say we are fucking cockroaches. When you fucking say A, we will say B. Until the entire ABCD start to happen. Okay, we are back. We are back to the base, guys, where we left. Appointments and condition of the officers of a judge as High Court. Okay, I think we read that. Removal of the judge. Oh, okay. We just read that, and it is not easy to fire us. Even a high court judge, I guess. Okay, even for firing a fucking high court judge, it will require you two-third of majority. You know, the Supreme Court judges and High Court judges have this much of a power. They still act in this cowardly fucking manner. Still, they act in this much of a cowardly manner, man. What? Tell me a Supreme Court judge literally, defining the government. Like some law made by the government or, uh, yeah, government, some law made by the Parliament of India. Like, yeah, a Supreme Court judge literally can do many things. And removing him is not an easy job. The office of a judge shall be vacated by his being appointed by the president to be judge of the Supreme Court or by his being transferred by the president to any other high court within the territory of India. Clause 2. A person shall not be qualified for appointment as a judge of high court unless he is citizen of India and I mean we don't know what makes a citizen. I mean, we literally don't know. Your Aadhaar card doesn't make you citizen of India. Your passport doesn't make you citizen of India. Your ration card doesn't make you citizen of India. Your birth certificate doesn't make you citizen of India. Your DNA doesn't make you citizen of India. I mean, what? I mean, what? What the fuck makes you citizen of India, man? I mean, like now the Supreme Court judges and High Court judges, man. Like, what is the proof you are citizen of India, man? You have to tell us that. Maybe Bajrang Dal and RSS membership makes you citizen of India. Maybe that makes you citizen of India, man. I mean, even your passport doesn't make you a citizen of India. Which other countries consider you to be a citizen of India? I mean, like, I don't fucking know, man. What the fuck are these motherfuckers talking about? Obviously, these motherfucker fascists are using it so they can, remove a certain section of population and make their lives miserable, by, removing their citizenship and many rights that come with it. That's why, this can't make you citizen of India, that can't make you citizen of India. They are doing it because of that. If something proves us citizen of India, then we can get it, okay? If in India you can get everything. You can get your death certificate while you are alive. You can get a degree in political science, which the university didn't offer. Everything can happen. Okay, I am gonna make a video on it. I'm gonna fucking make a video on this topic. The thumbnail will be "This makes you citizen of India." This makes you citizen of India. I will put this section there, and I will say, I don't know, man. Maybe the citizenship of India is the friends we made along the way. That was the citizenship of India, man. A person shall not be A person shall not be qualified for appointment as a judge of High Court unless he is citizen of India. And subclause A has for at least 10 years held a judicial office in the territory of India, or B has for at least 10 years have been an advocate of High Court or of two or more such court in succession. I mean, how was this calculated? When the before the commencement of the constitution, like where the previous judges just continued, or they were removed and new judges were assigned. It looks like the previous judges continued. For the purposes of this clause, in computing the period during which a person has held judicial office in the territory of India, there shall be included any period after he has held any judicial office during which the person has been an advocate of High Court or has held the office of member of tribunal or any post under the union or state requiring special knowledge of law. Okay. Double A. Subclause double explanation double A. In computing the period during which a person has been an advocate of High Court, there shall be included any period during which the person has held official judicial office or the office of member of tribunal or any post under the union of or a state requiring special knowledge of law after he become an advocate. Okay. Okay. 10 years. You have to held a position in law related things, and then you can become a judge, I guess, something like that. B. In computing the period during which a person has held judicial office in the territory of India or been an advocate of High Court, there shall be included any period before the commencement of this constitution during which he has held judicial office in any yeah, the people who were lawyers and judges, they were continued. Their time was actually considered. Yeah, I mean, you cannot just, make new lawyers up with this law. You have to go on with the previous ones. Constituting during which he has held judicial office in area which was comprised, compromised, or no, comprised. Fuck, man, I cannot even say English words. In an area which was comprised before the 15th day of August 1947 within India as defined by the Government of India Act 1935 or has been an advocate of any high court in such area as the case may be. I mean, you can also say any part of the word. What? Yeah, maybe. Maybe they only said parts of India because the laws are that are similar. Laws are similar to that period of India, which was it was a slave of Britain, and after that the laws were pretty similar. That's why you can continue on because the new India is also the slave. Just the masters are different, so you are not gonna require new knowledge of it anyway. You know. Otherwise, I don't see any reason why the fuck this motherfucker should continue. Yeah, hire new people, man. We studied this constitution. But no, you continued people who were judges and lawyers before the commencement of the constitution. If any question arises as to the age of the judge of high court, the question shall be decided by the president after consultation with the chief justice of India, and the decision of the president shall be final. Okay. So basically, I think there is no age limit for I mean, I don't know, man. Okay, to the High Court judge, there is no age limit. Maybe there is. Article 218. Application of certain provision relating to Supreme Court to High Court. The provisions of clause 4 and 5 of Article 124 shall apply in relation to High Court as they apply in relation to the Supreme Court with the substitution of references to the High Court for references of the to the Supreme Court. Yeah, same laws or same provisions High Court has to follow as did the Supreme Court, I guess. Okay, I mean, I these are the pretty much the most stupid articles. Like, why you are putting it here, man? Like, this is Constitution of India, man. Like, oath or affirmation by judges of high courts. Why you are putting this is very stupid. Okay, is this a religious book or something? Oath and affirmation. Like, do you and they do anything? I mean, you can just made a article like yeah, maybe if you want to take a vote there, you can take a vote in any religion book or some speech you wanna give when you are coming. You can go and give that. Yeah, there's just one article. Like I've read like at least 3, 4 articles of this type. I don't know, man. Why this kind of articles are put here? I don't see any use of it. Every person appointed to be judge of a high court shall, before he enters upon his office, make and subscribe before the governor of the state or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. Okay. Article 220 restriction on practice after being a permanent judge. No person who, after the commencement of this constitution, has held office as a permanent judge of High Court shall plead or act in any court or before any authority in India except the Supreme Court and the higher courts. Okay. Uh, Explanation in this article, the expression High Court does not include High Court for a state specified in Part B of the first schedule as it existed before the commencement of the Constitution. Seventh Amendment Act 1956. Okay. I don't think there is anyone calling themselves permanent judge now, so I think this is pretty much useless. And this was something related to colonial era Indian judges. Okay, I don't think so. This is relevant. Article 221 salaries etc. of judges. There shall be paid out to the judges of each high court such salary as may be determined by parliament by law. There shall be paid to the judges of each high court such salaries as may be determined by parliament by law and until provision in that behalf is so made. Such salaries as are specified in the second schedule. 2. Every judge shall be entitled to such allowance and such rights in respect of leave and of absence and pension as may from time to time be determined by or under law made by parliament and until so determined to such allowance and rights as specified in the second schedule, provided that neither the allowances of judge nor his rights in respect to leaves of absence or pension shall be varied to his disadvantage after his appointment. Okay. Article 222. Transfers of judge from a high court to another. Clause 1. The President may, on the recommendation of national judicial appointments, refer to Article 124A, transfer a judge from a one high court to any other high court. When a judge has been or is so transferred, he shall during the period he serves after the commencement of the Constitution 15 Amendment Act 1963 as a judge of the other High Court be entitled to receive in addition to his salary such compensatory allowances as may be determined by Parliament or by law until so determined such compensatory allowances as the President may by order fix. Oh man. Ah man, I think you should just write a book, another book called Salaries of Important Government Employees, and you can write that and just make a reference like salaries of this guy will be decided by that. Don't come and write it here. And I think there should be a book which you release and salaries of every high court judge, every supreme court judge, and how much the government spends on their or expenses of the government that are caused by these judges should be noted and be publicly available. Or is there such type of book? I don't know. Maybe I should find out. Okay, Article 223. Appointment of acting Chief Justice. When the office of Chief Justice of High Court is a vacant or when any Chief Justice is by reason of absence or otherwise unable to perform the duties of his office, the duties of the office shall be performed by such one of the other judges of the court as the president may appoint for the purpose. अ, हाँ, सारा जो सुप्रीम कोर्ट में है वही यहाँ पर चेप दिया है। हाँ हाँ, ठीक है ना, समझ में आ गया भाई। आर्टिकल 224 अपॉइंटमेंट ऑफ 224 or 224. I mean either of the thing. Both are right, man. Okay, it's not like one is more right. Appointment of additional acting judges. Clause 1. If by reason of any temporary increase in the business of High Court or by reason of arrears of work therein. Never heard arrears. Okay. Maybe the work that is pending or due. So that is that. It appears to the president that the number of the judges of that court should be for the time increase. I mean, the presidency of India is pretty much the under the control of prime minister currently, and also since time immemorial of the constitution. So I don't know, what is this, symbolic president power? Like just say prime minister, man. Like prime minister is the pop of all everybody. Just president is just a face put somewhere somebody of minority or something, so you can dance upon his name, but he has no power. Okay, he can be removed by the prime minister any day of the week. It appears to the president that the number of the judges of that high court should be for more the time being increased. The president may in consultation with the National Judicial Appointment Commission appoint duly qualified person to be additional judges of the court for such period not exceeding 2 years as he may specify. Shit. Hello. Okay, the voice is coming. Notwithstanding anything in this chapter, the National Judicial Appointments Commission on a reference made to it by the Chief Justice of High Court for any state may with the previous consent of the President request any person who has held the office of a judge of that court or any other high court to sit and act as a judge of the high court for that state, and each every such person so requested shall while so sitting acting to be entitled to such allowances as the President may by order determine and have all the jurisdiction, powers and privileges of, but shall not otherwise be deemed to be a judge of that high court. Okay, he will not be deemed a judge, but he will be a judge. I don't know, man. Provide that nothing in this article shall be deemed to require any such. Provided that nothing in article shall be deemed to require any such person as appropriate to sit and act as a judge of the high court unless he consent to do so. Consent matters, boys. You know. Consent matters. Don't do things without the consent of the other party. You may be in great trouble. All right, all right. Article 225. Jurisdiction of existing high courts, subject to the provisions of this constitution and to the provisions of any law of the appropriate legislature made by approved by virtue of powers conferred on that legislature by this constitution. The jurisdiction of and the law administration and any existing high court and the respective powers of the judges thereof in relation to the administration of the justice in the court, including any power to make rules of court and to regulate the settings of the court and of member thereof sitting alone or in division court, shall be the same as immediately before the commencement of this constitution. Okay, I am unable to understand this article. I will try to reread in my head and I will try if I can understand it. I will try. If I can't, then it's fine, okay? Like, okay, I am unable to understand it. I will move forward. Article 226. Power of High Courts to issue certain writs, notwithstanding anything in Article 32. Every high court shall have power throughout the territories in relation to which it exercises jurisdiction. Okay, we will take the jurisdiction the यानी कि जिस एरिया में जिस एरिया तक इनका इनकी हाउ कैन आई प्रोनाउंस jurisdiction यानी कि एरिया a particular area where you know judgments made by them apply and up like something like that. This is my territories and I make the rules here, something like that. And once you leave that territory, my rules may no longer apply, such as the Maharashtra High Court has a jurisdiction of the Maharashtra current state boundary, something like that. Okay, I am taking it as that. I don't know. The to issue to any person or authority, including in appropriate cases, any government within those territories direction, orders or writs, including writs in the nature of habeas corpus. What the fuck is habeas corpus mean? Okay, I mean जिसको कोर्ट के सामने बंदे को लाना mandamus. Like these Latin terms are shithole, man. Like habeas corpus maybe little bit of okay word like mandamus. What the fuck is a common law prerogative writ that compels a court or government officer to perform mandatory or purely ministerial duties correctly? Okay. Prohibition. Quo warranto. Okay. A legal proceeding used to challenge the right of an individual or corporation to hold a public office or exercise a certain franchise or privilege. Okay. Ser- certiorari. Certiorari. Okay, man, it is difficult to pronounce. Okay, even the dictionary doesn't have. I mean, it has to. Wait, we will do it correct. A grant of the right of an appeal to be court, where the court has discretion to choose which appeals it will hear. Okay. हेबिस कॉर्पस यानी कि किसी भी बंदे को तुम बुला के ला सकते हो फॉर कोर्ट्स प्रोसीडिंग मैंडामुसिस यानी कि किसी भी ऑफिसर या मिनिस्टर की पोजीशन को तुम उसको ये कर सकते हो कि तू ये चीज़ें फॉलो नहीं कर रहा तेरी ड्यूटीज़ को नहीं फॉलो कर रहा एंड दे कैन राइट दैट को वारंटो मीन्स कि किसी इंडिविजुअल या कॉरपोरेशन को चैलेंज करना कि ये तुम्हारी राइट नहीं है और तुम इस तरह से नहीं बिहेव कर सकते ओके सेरेटोरी the court can hear certain appeals or any of them for the enforcement of any of the rights conferred by part 3 of or any other purposes. Clause 2 the power conferred by clause 2 1 to issue directions orders or writs to any government authority or person may also be exercised Yeah, I think the current, I think High Court order इश्यू कर दिया सोनम वांगचुक की चेकअप करो गवर्नमेंट को या इसको किसको किसको भी क्या हो गया monitor his health. The court ordered it by any high court exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises for the exercise of such power. Notwithstanding that such government or authority or residence of such person not within in those territories. Okay, where any party against whom an interim order, whether by way of injunction or stay or in any other manner, is made or in any proceedings relating a petition under clause 1 without subclause A, furnishing to such a parties copies of such petition and all documents in support of the plea for interim order, and B, giving such party an opportunity of being heard. Makes an application to the High Court for the vacation of such order and furnishes a copy of such application to the party in whose favor such orders has been made or the counsel of such party. The High Court shall dispose of the application within a period of 2 weeks from the date on which it is received or from the date on which the copy of such application is furnished, whichever is later, or where the High Court is closed on the last day before the application is not disposed of. The interim order shall, on the expiry of that period, or as the case may be, the expiry of the said next day, stand vacated. The power conferred on a High Court by this article shall not be derogation of the power confirmed on the Supreme Court by Clause 2 of Article 32. Okay, the power of High Court can't override, I guess, the power of Supreme Court, which is obvious. Article 2026A Constitution validity of central laws not to be considered in proceeding under Article 2026 at 220 226 omitted by the Constitution 43rd Amendment. Okay, this is clear signs I am getting lost in thought and saying dumb shit. Yeah, I'm stopping here. I'm not gonna continue on as I already have hit the mark that I have set up for myself, which was 1 hour and then 30 minutes. I am already at 1 hour and 35 minutes. So yeah, I will stop here. With on next Monday we will continue with Article 227. If you are watching this, please consider subscribing and liking. Bye bye. I will be streaming tomorrow. Maybe I don't know. But let's see.